This is part 2 of our immigration court series. You're going to immigration court, or someone you know, someone you may love, a spouse or a child, has a date in immigration court. And you're trying to figure out what's going to happen, or can you do it alone? This is our second part in a multi-part series to help you figure those questions out, to help you figure out your answers so that you know how to proceed forward. In this presentation, I'm going to discuss the second major point, the notice to appear. How do you know you have a date in immigration court? Well, you've been given a piece of paper, a 2-page document, and that document should tell you what date, what time, and what court location to appear at. It's called a notice to appear. Lawyers and judges call it an NTA, notice to appear. And it's crucial for beginning your case. What's happened in recent years is that the very documents that start a case have been challenged because either the government, when they serve a person, when they give a person this document, either does not list the date or time or precise location, and therefore the notice isn't valid. A non-lawyer probably wouldn't know that, but lawyers who practice immigration law, who have been trying to come up with defenses, say you can't just put someone in court without a date and time and then expect them to abide by the law. And the reason this is crucial is that oftentimes the day they give you that piece of paper, the day you're served, is the date for your claim for relief, for maybe trying to get a green card, is cut off. Because certain rules will say you have to be in the U.S. so many years, 5 years or 7 years. And by giving you that earlier date, without a date, but just saying you have to appear, and counting it against you may prohibit you from picking up the 5th year. Perhaps you've been in that category 4 years, 11 months, and 17 days, and they give you the sheet called the notice to appear, the charging document, and you go to court and the judge says you're cut off. You can't claim that relief. But they didn't give you the date until maybe 30 days later or 60 days later. So why should you be cut off? That's a technical issue to the very document that starts your case. So if you have one of those documents, pull it out right now and look at it. I'm going to tell you what section to look at and tell yourself, what does it show me? So let's go through that charging document. There's 6 points that you need to understand. The first is your biographical information, your name, your address, your telephone number, and your immigration number. Now, if you have an immigration number from the past and they know it, that means you have an immigration history. They already have you in the system for other things. Hopefully, those other things won't cause problems. But sometimes those other things are incidences where you were stopped at the border, or perhaps you were picked up by ICE. Maybe you've even been deported before. Or maybe you applied for something and you lost, but they never sent you to court on that. But they might have thought what you filed was fraudulent. If you have an A number, you have a history. And you have to think, what is that history? You get a new A number with immigration court, but you might already have a number. The second thing it shows you is the nature of the proceedings. What that means is, were you stopped at the border? Or are you someone that they picked up, you were living in the United States, but you had entered without permission? Or were you living here with permission, but you violated some kind of rule? And so you ended up in immigration court, which leads to the third point, the factual allegations. So take, for instance, someone that entered with a fiancé visa. They entered legally and they were supposed to get married by a certain day and they didn't. and somehow their visa's expired, and the government sends notice, USCIS sends notice to ICE or the immigration court, and then all of a sudden you're charged with being here as an overstay. You've broke the rules for allowing you to stay here. Or perhaps you're a permanent resident, but you've been convicted of a certain crime. And that crime is considered rather serious by the immigration court. And so now those are going to be part of the factual allegations. Number 4 on the charging documents is the charges of removability. So if you have some violations like that, or you entered without permission, now the government's going to cite some rules. What are they charging you with? What are the reasons that they believe they can deport you, send you back home? Now, the last 2 points, the factual allegations and the charge of removability, or the charge of deportability in common language, the judge will ask you to admit or deny. And if you have no legal training, you have to be careful what you're admitting and what you're denying. Even if it's truthful, you need to consider how it's truthful, because that alone could be a technical issue. And this is why in the first video, I said some cases, people who go to court alone win easily without much fight, because there's really not much there. But in other cases, there are some technical issues there that an attorney might want to fight and dispute to help keep you in this country, to help you win a green card that you won't know. But that's why pro pers, people going alone to court, lose 80% of their cases, because they don't know, they won't know all these technicalities in most instances. And so they let it go, and boom, they don't raise the issue. It's not going to help them. It can only hurt them. So when you're thinking about, again, doing your case on your own at immigration court, think very carefully what type of case you are, and think very carefully about the allegations and charges against you. Next is the issue I asked you to think about at the outset of this presentation: date and place and time of your hearing. Item number 5 will list that. Look at it. Does it say at a date to be determined, at a place to be determined, at a time to be determined? Or does it give you a specific information? July 7th, 2022, at the Los Angeles Immigration Court at 1:30 p.m., which is located at 606 South Olive Street. Read that line very carefully, because that could be a technical issue that could end up making or breaking your case. Item number 6 on the notice to appear are the legal warnings. You have the right to an attorney at your own expense. You have a duty to attend your hearings. If you don't attend a hearing and there is not a good reason for it, and you don't inform the court, the judge can enter what is called an in absentia order. That was the person served correctly? They'll ask ICE. Yes. How were they served? ICE will respond. And they'll say, if you have an attorney, you'll ask the attorney, you know why they're not here? No. Boom. Then I'm going to issue an order of deportation. Now you've been deported simply because you didn't show up. And that's another reason why I tell people, get to court an hour early. You know, you have traffic and stuff, just get there early. You don't want that kind of order against you. And you also have a duty to inform the court of a change of address. Like sometimes people will say, well, I didn't know that the government wanted me to respond to this because I was no longer at that address. Well, it's your duty to inform the court. It's your duty to inform the Department of Homeland Security. You don't do that, and they could easily say, but wait a minute, you have a duty to inform us, and we told you about that earlier, and you didn't do it. So why should that be our fault that you didn't get that information? That's your fault because you're not following the rules. And of course, there's a duty to surrender if the judge orders you to be deported. All of those are critical rules that you need to know. And all of those are in that document called the notice to appear. the NTA. Do not think of it as just a simple 2-page document that tells you when to go to court. It's much, much more important than that. So read your document carefully. Be sure you understand it, because that's going to be critical, not only to when you go to court, but your decision whether you're going to try to do this alone or not. I'll see you in the next video. Take care. Bye. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below, or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time, and hopefully we'll be talking again very, very soon.